Chapter 7 Paternity Establishment. In the Court's introduction through the ages, the status of illegitimacy has expressed society's condemnation of irresponsible liaisons beyond the bonds of marriage. But visiting the condemnation on the head of an infant is illogical and unjust. Moreover, imposing difficulties on the illegitimate child is contrary to the basic concept of our system that legal burdens should bear some relationship to individual responsibility or wrongdoing. Obviously, no child is responsible for his birth, and penalizing the illegitimate child is an ineffectual as well as an unjust way of deterring the parent. Courts are powerless to prevent the social opprobrium suffered by these hapless children, but the Equal Protection Clause does enable us to strike down discriminatory laws relating to status of birth where the classification is justified by no legitimate state interest, compelling or otherwise. Weber v. Aetna Casualty and Surety Co. 406 U.S. 164, 92 S.It. 1400, 1406-07, 31 led to 768, 1972. With this case, the U.S. Supreme Court initiated the constitutional transformation of the status of children born out of wedlock. The common law beheld the illegitimate child as filius nullius, the child of no one. The status was so undefined that the legal tie between the child and his or her mother was not easily established, and no legal mechanism existed to establish paternal identity. Since 1968, the Supreme Court has handed down a number of decisions which dictate that neither the federal government nor the states may discriminate against illegitimate children without a substantial and proper state interest as justification. See Levy v. Louisiana, 391 U.S. 68, 88 S.It. 159, 20 led 2D 436, 1968, Glona v. American Guarantee and Life Inns Co. 391 U.S. 73, 88 S.It. 1515, 20 led 2D 441, 1968, Labine v. Vincent, 401 U.S. 532, 91 S.It. 1017, 28 led 2D 288, 1971, Weber v. Aetna Casualty and Surety Co. Supra, Gomez v. Perez, 409 U.S. 535, 93 S.It. 872, 35 led 2D 56, 1973, New Jersey Welfare Rights Org. v. Cahill, 411 U.S. 619, 93 S.It. 1700, 36 led 2D 543, 1973, Jimenez v. Weinberger, 417 U.S. 628, 94 S.It. 2496, 41 led 2D 363, 1974, Matthews v. Lucas, 427 U.S. 495, 96 S.It. 2755, 49 led 2D 651, 1976, Trimble v. Gordon, 430 U.S. 762, 97 S.It. 1459, 52 led 2D 31, 1979, Lally v. Lally, 439 U.S. 259, 99 S.It. 518, 58 led 2D 503, 1978, United States v. Clark, 445 U.S. 23, 100 S.It. 895, 63 led 2D 171, 1980. Concomitant with the establishment of constitutional rights for children born out of wedlock were two other social trends. The first and foremost was the growth of out-of-wedlock births. The second was a growing sensitivity in Congress and state legislatures regarding the importance of paternity establishment to the child and the cost to society of supporting a significant percentage of these children through public assistance. See Chapter 1, Supra. Thus, the creation of an equal right to support coincided with an increased awareness of the need to quantify and enforce that right. Congress responded in 1975 by creating the Child Support Enforcement Program. 42 U.S.C. 654-4, and 6, require each state plan for child support enforcement to provide that the state and all relevant political subdivisions will endeavor to establish the paternity of all children who were born out of wedlock and who receive AFDC or who have made application for non-AFDC services. 42 U.S.C. 654-9 extends the responsibility to include cooperation with other states in establishing paternity across state lines. Thus, the establishment of paternity is not merely an ancillary responsibility to that of collecting child support. The federal statute clearly establishes an independent obligation on the states to seek paternity establishment in its own right. Neither the Social Security Act nor federal regulations dictate the form that paternity establishment must take. Clearly, since the main concern of the 4D program is support enforcement, any method of establishment must be binding on the alleged father and should include an enforceable support obligation. Traditionally, in our legal system, facts are established and obligations are imposed through the entry of a judgment, or its legal equivalent. This chapter assumes that, in order to fulfill the statutory responsibility, such formality is necessary. Preliminary issues jurisdiction. Two fundamental issues must be resolved prior to filing a paternity action. Which local court possesses subject matter jurisdiction over paternity actions? Can that court obtain personal jurisdiction over the prospective parties to the action, requisite to render a valid, enforceable judgment of paternity? Where the alleged father resides within the state, the issue of subject matter jurisdiction ordinarily is resolved by simple reference to the state's paternity statute. In addition to filing an action pursuant to the paternity statute, it is sometimes possible to file an action under a declaratory judgment statute, or under the intrastate mechanism of the Uniform Reciprocal Enforcement of Support Act, URASA. Using such an alternative can be an effective way to avoid filing actions under an outmoded criminal bastardy statute, of creating subject matter jurisdiction in a court that lacks specific statutory authority, and perhaps of avoiding the necessity of granting the alleged father a trial by jury. Paternity actions are in personam in nature, meaning that the court must obtain jurisdiction by service of process made on the defendant in accordance with state statute or court rule. S for defendants located within a state's territorial boundaries, state service of process and venue statutes and court rules should be consulted. The thorny legal issue arises when the alleged father resides out of state and cannot be served within the state. One approach to this situation is a URASA action. Section 27 of the 1968 version of the Act specifically provides for interstate paternity determinations. In addition to the language in the newer version of the Act, most appellate courts that have considered the issue have held that paternity jurisdiction is included in the original version of the Act as well. See Clarkston v. Bridge, 539 P2D 1094, or Bank 1975, State of Lower Exral. Norman v. Troutman, 623 SW2D 269, Mo.App. 1981, 81 Al 3D 1175, 1977, due to evidentiary problems, which make contested URASA paternity cases difficult to pursue, and the reluctance of some jurisdictions to cooperate in interstate paternity establishment, it may be more effective to bring the action in the state where the children reside. A thorough, though outdated, annotation of this issue appears at 76 ALR 3D 708, 1977. See also Levy, asserting jurisdiction over non-resident putative father in Paternity Act URIS, 45 U.Sin.L. Rev. 207, 1976, in Penoya v. Neff, 95 U.S. 714, 24 Led 565, 1878. The U.S. Supreme Court established the principle that a court's jurisdiction over persons is generally coextensive with the boundaries of the state in which it sits. During the next several decades, exceptions to this general rule developed to allow courts to exert jurisdiction over persons no longer physically present within the state. The exceptions very nearly devoured the rule and tread heavily on the Due Process Clause of the 14th Amendment to the U.S. Constitution. The High Court responded with the landmark case of International Shoe v. Washington, 326 U.S. 310, 66 SET 154, 90 Led 95, 1945, which set forth the familiar principle that a court may exercise jurisdiction over out-of-state defendants whose prior presence or activity within the state amounted to certain minimum contacts with the state, such that traditional notions of fair play and substantial justice are not offended by allowing the suit to be maintained in that court. Subsequently, in Hansen v. Dentler, 357 U.S. 235, 78 SET 1288, 2 Led 2D 1283, 1958, the court added the requirement that the defendant's contact with the forum state must have been purposeful and of a nature that availed him of some benefit conferred by the state along with the privilege of conducting the activity that constituted the contact. The U.S. Supreme Court has had no opportunity to apply this line of case law to a paternity action maintained against an out-of-state alleged father. For nevertheless, many state courts have been presented with the issue. The emerging test for personal jurisdiction is two-pronged, requiring the existence of and compliance with a state statute or court rule that authorizes service of process outside the state and facts that meet the international SHU, Hansen v. Dentler due process requirements. Because few states have enacted long-arm statutes that specifically provide for extraterritorial service of process in paternity actions, much of the case law has centered on the first prong of the test. The issue is, does the defendant's alleged participation in the conception of the child or his subsequent failure to support him or her, amount to a tort, as the term is used in the long-arm statute? The split of authority on this issue has been roughly even. At least 6 courts have broadened the definition of tort to encompass the paternity and support action. Poindexter v. Willis, 87-3 App. 2D 213, 231 NE 2D 1, 1967, State Ex Rel. Nelson v. Nelson, 298 Minnesota. 438, 216 NW 2D 140, 1974, Howells v. McKibben, 281 NW 2D 154, Minnesota. 1979, Neal v. Ridner, 153 Indiana. App. 149, 286 NE 2D 427, 1972, Bacora v. Borkin, 14 Arizona. App. 569, 485 P2D 292, 1971, Inri Miller, 86 Wash.2D 712, 548 P2D 542, 1976, Black v. Rasile, 318 NW2D 475, Michigan.ct.app. 1980, an equally impressive number of courts have refused to stretch the tort definition. State Ex Rel. Larimore v. Snyder, 291 NW2D 241, Nebraska. 1980, Howard v. Crayhead Company, CT, 613 SW2D 386, ARC. 1981, Barnhart v. Madvik, 526 SW2D 106, Tennessee. 1975, ARB v. GLP, 180 Cullo. 439, 507 P2D 468, 1973, State Ex Rel. Carrington v. Schutz, 217 Can. 175, 535 P2D 982, 1975, Anonymous v. Anonymous, 49 MISC 2D 75, 268 NISC 2D 710, FAM.CT. 1966, State Ex Rel. McKenna v. Bennett, 28 or App. 155, 558 P2D 1281, 1977, Inri Jane Doe 38 Wash.app. 251, 684 P2D 1368, 1984, Illinois v. Fleer, 124 IL.App.3D 604, 83 December 739, 465 NE2D 1376, 1984. These decisions have noted that, logically, the broad definition of tort, duty plus breach, applies only to the support claim, which is ancillary to the underlying action for declaration of paternity. The act of sexual intercourse itself, even given the resulting conception, does not cause tortious injury or damages, so the argument goes. The alleged father's subsequent breach of his duty of support is analogous to the legal concept of tort. Nevertheless, since it was solely the act of sexual intercourse that occurred within the forum state in each of the cited cases, the courts were held to lack jurisdiction over the underlying claim, and the ancillary claim failed along with it. As one would expect, the no-tort decisions do not analyze the second prong in the test, the minimum contacts analysis. Two pro-tort cases, Howells v. McKibbin, Supra, p. 157, and Larson v. Skull, 296 NW2D 785, 788, lower 1980, set forth the following 5 criteria: the quantity of the alleged father's contacts with the forum state, the nature and quality of those contacts, the source and connection of the paternity action with those contacts, the interest of the forum state in paternity establishment and support enforcement, the convenience or inconvenience to the parties that results from allowing the forum state to assert jurisdiction. In both of these cases, which involved repeated social and sexual intercourse within the forum state, a mother and child very much in need of financial support from the alleged father and an alleged father who lived nearby in a neighboring state, jurisdiction was held to exist. 4 appellate courts have rendered contrary decisions where the child was conceived out of the state, despite the forum state's recognized strong interest in providing a remedy. Ulmer v. O'Malley, 307 NW2D 775, Minnesota. 1981. Bartlett v. Superior CT, 86 calories. App.3D 72, 150 calories. RPTR.25, 1978, Barnhart v. Madvig, Supra, State v. Schaffer, P2D-11 floor 1100, Arizona. App. 1984. Right to appointed counsel. Does an indigent paternity defendant have an absolute constitutional right to counsel at public expense? Recent decisions have held that no such absolute right exists, at least under the Due Process Clause of the U.S. Constitution. State ex rel. Hamilton v. Snodgrass, 325 NW2D 740, lower 1982, Wake Company ex rel. Carrington v. Towns, 293 NE2D 95, NC 1982, Nordgren v. Mitchell, 716 F2D 1335, CA 10 1983, State ex rel. Adult and Family Serve. Diff. v. Stout, 57 or. App. 303, 644 P2D 1132, 1982, see also Shepard v. Mack, 68 Ohio. App.2D 95, 427 NE2D 522, 1980, State v. Walker, 87 Wis.2D 443, 553 P2D 1093, 1976, and Johnson v. James, 38 Wash. App.264, 10 floor 1564, 1984. Prior to these decisions, a contrary rule was emerging, as exemplified by the California Supreme Court decision in Salas v. Cortez, 24 calories. 3D 22, 154 calories. RPTR. 529, 593 P2D 226. Cert. Den. 444 US 900, 100 SET 209, 62 Led 2D 136, 1979. The recent change can be attributed to the U.S. Supreme Court's decision in Lasseter v. Department of Social Services, 452 U.S. 18, 101 S.E.T. 2153, 68 led 2D 640. 1981. Lassiter involved a parental rights termination proceeding instituted against an indigent mother. The court held that an absolute right to appointed counsel exists only where an indigent defendant is likely to be incarcerated or receive comparable loss of liberty as a result of the present proceeding, should he or she not prevail. Where no immediate potential for incarceration exists, a strong presumption against appointment of counsel arises. This presumption may be rebutted. Matthews v. Aldridge, 424 U.S. 319, 96 S.E.T. 893, 47 led 2D18, 1976. Under the Aldridge analysis, a qualified right to appointed counsel exists where the defendant's substantial interest in the outcome outweighs the government's interest in economical and informal proceedings and where there exists a serious risk of an erroneous decision in the absence of counsel. The first four cases cited in the above paragraph apply this analysis to paternity cases brought against indigent alleged fathers by 4D agencies. Most post-Lassiter decisions concede that a man who is found to be a child's father in a paternity action runs a risk of future incarceration for civil contempt or criminal non-support and that the paternity judgment may be binding in such a proceeding. Nevertheless, the developing trend holds that the delayed and indirect nature of the threat to the defendant's liberty interest creates a presumption against the right to counsel. The trial court must decide whether the presumption is overcome in any given paternity case after conducting the balancing test set out above. The holdings point out that the alleged father's interest in the outcome of the action is substantial in both social and economic terms and that the state shares an interest in accurate paternity determinations. Despite these considerations, which tend to favor a right to appointed counsel, representation of the alleged father in the ordinary paternity case is not likely to decrease significantly the risk of erroneous decisions. The courts noted that paternity actions normally do not involve complex evidentiary issues and that genetic paternity test results will weed out erroneous allegations. As a result, the decisions appear to stand for the proposition that only in complex evidentiary situations should the balancing test result in a due process right to appointed counsel. 2. Clearly, the trial court is vested with a broad discretion in making the determination on a case-by-case basis. Two decisions have been rendered by state appellate courts, subsequent to Lassiter, that apply the Eldridge test to the paternity situation and reach the opposite result. In Kennedy v. Wood, 439 NE2D 1367, Indiana. App. 1982, and Kerr v. Cull, 451 A2D 480, Supra. 1982, the appellate courts in Indiana and Pennsylvania concluded that paternity actions are inherently complex and that a significant risk of erroneous decision exists whenever an indigent alleged father is not represented by counsel. That being the case, indigent alleged fathers are guaranteed a right to counsel in all paternity actions brought on behalf of the state. The significance of these two holdings should not be underestimated, given the trial court's broad discretion in applying the test. Occasionally, defendants will argue that because the 4D agency provides counsel for the plaintiff in the paternity cases, the state has an obligation under the Equal Protection Clause to afford the defendant with the same benefit. Courts have held that a state's practice of representing plaintiffs and not defendants in paternity actions is rational and therefore constitutional, due to the common interest shared by the state and the plaintiffs. Department of Health and Rehab Services v. Heffler, 382 So 2D 301, Fla. 1980, State Ex Rel. Hamilton v. Snodgrass, Supra, p. 744. Two other decisions related to this topic are instructive. In Ramsey Public Defender's Office v. Fleming, 294 NW 2D 275, Minnesota. 1980. The Minnesota Supreme Court held that where an indigent alleged father is given a right to appointed counsel by statute, the state must inform him of that right prior to proceeding to judgment. White v. Gordon, 468 UD 828, Supra. 1983. held that non-indigent alleged fathers must be afforded a reasonable opportunity to obtain counsel. Right to state-financed paternity testing. The U.S. Supreme Court's decision in Little v. Streeter, 452 U.S. 101 S.It. 2202, 68 led to D. 627, 1981, and several state court decisions have firmly established the right of the indigent alleged father to state-financed genetic paternity tests. Most of the courts have applied the Eldridge test and concluded that the risk of erroneous decision is simply too high in the absence of scientific testing. Anderson v. Jacobs, 68 Ohio Street. 2D 67, 428 NE 2D 419, 1981. See also Michael B. v. Superior CT, 150 calories. RPTR 586, Cal.App. 1978, Walker v. Stokes, 344 NE 2D 159, Ohio App. 1975, Franklin v. Dist. CT, 571 P2D 1072, Cullo. 1977. Other courts have construed the state's version of the Uniform Parentage Act, UPA, to create a right in the parties to the tests, given the mandatory language in the statute forcing the court to order the tests upon the request of either party. Once such a right is recognized, equal protection may be held to prohibit the conditioning of the right on the alleged father's ability to pay. Kesey v. 266 SC 2D 146, W.Va. 1980. Still other courts have extended the right to state-financed tests on the theory that such tests are necessary to the alleged father's defense and are part and parcel of his right to appointed counsel, which exists in the state by reason of statute or case law. M. v. S. 169 N.J. Supra. 209, 404 A2D 653, 1979. The Supreme Court made much of the criminal nature of the Connecticut bastardy statute and its peculiar provision that requires the alleged father to bear the burden of proof on the ultimate issue where the complaining witness is constant in her allegation. 452 U.S. at 12. Under such a reading of Little, a statutory scheme that is truly civil and that places the burden of proof on the plaintiff at all times might not create a right to state-financed paternity testing for indigent defendants. Nevertheless, the trend in the appellate courts seems to be to apply Little to all types of paternity statutes. In what is perhaps the most far-reaching decision on this issue, the Georgia Supreme Court has held that the state must finance the tests whenever it is the moving party, regardless of the financial condition of the alleged father. Boone v. State, Department of Human Resources, 250 Georgia 379, 279 SC 2D 727, 1982. The decision points out that to allow the court to order the defendant to pay for even a portion of the test costs prior to a determination of paternity constitutes a taking without the necessary due process hearing. It might be possible to avoid the effect of this holding by asking the court for a preliminary hearing to determine the strength of the plaintiff's case. The statutes of many states provide for such hearings. The Boone decision specifically did not invalidate the court's authority to include in its eventual judgment a provision assigning the test costs to the losing party. According to appointed counsel decisions, a cost judgment may be entered against an indigent defendant with the proviso that he enjoys an exemption from execution of the judgment as long as his indigency continues. M. v. S. Supra, citing Fuller v. Oregon, 617 U.S. 40. 53, 94 S.It. 2116, 2124, 40 led to D 642, 1974. Right to jury trial. State statute generally determines whether a judge or jury will try a paternity proceeding. The issue finds its way into appellate case law when a state updates its paternity statute to provide for court-tried cases only, where the statute is ambiguous or silent on the issue, or where the state opts to file its paternity cases under a statute other than the paternity statute in order to avoid jury trials. Clearly, Avoiding the paternity statute is possible only where it is cumulative of other remedies and where a substitute remedy, such as a Declaratory Judgment Act or the eraser mechanism, exists. The issue also can arise where a local rule provides that unless a jury trial is requested in a specific manner by a specific date, the statutory right to trial by jury shall be deemed waived. The manner in which a constitutional right can be waived differs from the manner in which a mere statutory right can be waived, so the classification of the right can be important. The historical nature of paternity proceedings as quasi-criminal and the fact that the state, with all its resources and expertise, is maintaining the action can cause a judge to react favorably to the alleged father's demand for trial by jury. Nevertheless, a good argument can be made for the proposition that jury trials are not appropriate for paternity cases for a number of reasons. Docket delays of over a year are not uncommon. Jury trials can last several days, using up valuable court and attorney time, whereas a bench trial normally can be completed in half a day. The evidence is of a highly personal nature and, as is the case with juvenile court proceedings, should not be affected by the chilling effect of public disclosure. The delay factor acts in the favor of the alleged father by allowing him additional freedom from his support obligation, which has the further effect of providing a disincentive to negotiation and settlement. Courts that have addressed the issue of an alleged father's constitutional right to trial by jury in a paternity case have found that right to be non-existent. State Ex Rel. Goodner v. Speed, 96 Wash.2d 838, 640 p2d 13, 1982, State Ex Rel. Thomas v. Cahill, 443 A2d 497, Supra. 1982, Robertson v. Apostso, 170 Connecticut 367, 365 A2d 824, 1976. Since the Seventh Amendment does not apply to the states, the constitutional analysis centers on the language of the applicable state constitution. State constitutions generally contain a clause that reads something like the right of trial by jury shall remain inviolate. 12. This type of clause generally is construed to mean that any right to jury trial that existed at common law, on either the date the Constitution was adopted or the date the Constitution specifies as being applicable, cannot be abridged by legislative enactment. The three decisions cited above note that there was no such thing as a common law action for declaration of paternity and support, illegitimate children being without a common law right to support from their fathers. That being the case, no right to jury trial existed and the legislature is free to grant or revoke the statutory right at any time. The Robertson case is particularly interesting. It holds, at p. 832, that the state may deny a jury trial to those alleged fathers who are unable to tender a $100 fee. The fee was held to be rational, given the additional costs inherent in jury trials, and thus free from equal protection problems. Statutes of limitation. Historically, the existence and extent of statutory limitations placed upon the bringing of paternity actions have varied widely among jurisdictions. The Uniform Act on Paternity, UAP, 9 AULA seconds. 3. Encourages states to enact a limitation only as to the father's liability to reimburse the plaintiff for support provided to the child in the past in lieu of a limitation that would bar the action for declaration of paternity. At least one court has construed a general statute of limitation to operate in such a manner. Winston v. Robinson, 270 Arc. 996, 606 SW2D 757, 1980. In 1979, the Minnesota Supreme Court went one step farther by holding that the continuing nature of the support obligation tolls the operation of any statute of limitation throughout the child's minority. D. V. R. 277 NW2D 27, Minnesota. 1979. See also, Sutherland v. Horin, 605 P2D 1133. Montana 1980, Matter of MDH, 437 NE2D 119, Indiana. App. 1982, 16 ALR 4th 926, 1982, Numerous recent cases have analyzed statutes of limitation, as applied to paternity actions, for possible equal protection violation. The applicable equal protection standard was set forth in Gomez v. Perez, 409 U.S. 535, 1973, which requires all states to provide illegitimate children an opportunity to obtain paternal support on a more or less equal footing with the opportunity provided legitimate children. The decisions of state courts have been decidedly inconsistent. 13 Recently, the U.S. Supreme Court has handed down two decisions on point. In Mills v. Haber-Lutzel, 456 U.S. 91, 102 S.It. 1549, 71 led 2D 770, 1982, the court struck down the Texas one-year statute of limitation. In Pickett v. Brown, 103 S.It. 2199, 76 led 2D 372, 1983, the Tennessee two-year statute was invalidated. Under both decisions, the first issue in the equal protection analysis is whether the limitation period is sufficiently long to provide those with an interest in illegitimate children to bring suit on their behalf. Justice O'Connor's concurring opinion in Mills, p. 105, and Justice Brennan's majority opinion in Pickett both stress that the mother's strained financial condition and the possibility that she may be trying to maintain her relationship with the child's father as well as other social and economical factors may act to inhibit her from filing an action against the father. The fact that a statute may toll the running of the limitation period where the father is providing support or has acknowledged his paternity in writing, or that an exception is made for children who are likely to become public charges, does not necessarily act to mitigate the inhibiting factors in a significant number of potential paternity actions. Pickett, p. 2209. Large caseloads can produce a similar inhibition on the states, which often stress cases with a better potential for recovery than contested paternity cases. The second issue for inquiry under the two holdings is whether the time limitation placed on the bringing of the action is substantially related to the state's interest in avoiding the litigation of stale or fraudulent claims. Both 1 and 2 year periods fail this test. The fact that in Texas and Tennessee the limitation periods applicable to other legal actions are told during a child's minority was seen to damage seriously the state's argument that the statutes were necessary to avoid stale or fraudulent claims. Many civil actions are fraught with problems of proof, but the states could offer no justification for treating paternity actions differently. Both decisions pointed out that recent developments in scientific paternity testing attenuate any connection between the statute and a state's interest in avoiding stale or fraudulent claims. Although both decisions refused to go so far as to hold that the availability of the tests negates a state's argument altogether. It seems clear that the rationale behind Mills and Pickett eventually will be applied to periods in excess of 2 years, but the point at which a state's interests begin to outweigh the illegitimate child's fundamental need for paternity establishment is unclear. The equal protection test is too subjective to provide a predictable answer. The only clues currently available come from recent state court decisions. 3-year statutes of limitation have been struck in Montana, North Carolina, Kentucky, and West Virginia. In Florida, a 4-year statute has been invalidated. A 6-year period has been upheld in Michigan and struck in Oregon. 15. The Pennsylvania Superior Court rejected an equal protection challenge to its 6-year limitation on establishing paternity. This decision was appealed to the U.S. Supreme Court but remanded when the Pennsylvania state legislature appealed the statute. Paulson v. Herion, 483 A2D. 892, 1984. Louisiana's new 19-year statute was upheld in re Grice, so 2D-11 Floor 1173, La.App. 1985. In addition to attacking the constitutionality of a statute of limitation, it is often possible to avoid its application to a specific case by bringing the case within a tolling provision. As noted above, it has been held that a provision which tolls the running of all limitation periods during a child's minority supersedes the limitation period contained in the paternity statute. Other facts that may amount to a tolling of the statutory period include an oral or written acknowledgement of paternity, providing support for the child, or leaving the jurisdiction. Also, the defendant generally must inject the bar of a statute of limitations as an affirmative defense or it is deemed waived. Thus, the existence of the statute does not completely bar the door to the courthouse. Congress addressed the Statute of Limitations issue in the Child Support Enforcement Amendments of 1984. 42 U.S.C. 666, A5, now requires each state to enact laws that provide procedures which permit the establishment of the paternity of any child at any time prior to such child's 18th birthday. Compliance with this requirement will decide many of the issues raised above, at least as to cases in which the child is conceived or born after the change in the statute of limitation or within the previous statutory period. Congress language would seem to require application of the new statutory period to existing cases as well. Because statutes of limitation generally are viewed as procedural, being a potential bar to the remedy and not the underlying cause of action, a change may be implemented retrospectively. See Roe v. Doe, 581 P2D 310, Hawaii 1973, Wolf v. Goyne, 552 P2D 258, or App. 1975, Sutherland v. Horin, 605 P2D 332, 1980, State v. Preston, 409 A2D 792, NH 1979. Nevertheless, some courts and legislatures may conclude to apply the change prospectively. In these states, the recent case law, discussed above, will continue to be relevant as program attorneys seek to avoid the bar of a previous statutory period. Settlements. Two issues come up regarding the settlement of paternity cases. First, what effect does a settlement agreement between the mother and alleged father, which predates the opening of the 4D case, have on the state's ability to establish paternity or modify the support amount? Second, what procedure must be employed to create a valid, enforceable consent judgment? Since the overwhelming majority of 4D paternity actions are resolved by way of agreement, the importance of the answers to these questions cannot be overstated. Assume that the mother and the alleged father have entered into an agreement whereby she agreed not to press a paternity action against the alleged father in exchange for a lump sum payment of $500. Assume further that the agreement was a simple out-of-court settlement, with no judicial scrutiny or approval, and assume that the alleged father complied with his agreement to pay the $500. Now assume that circumstances change. Either the mother becomes financially destitute and turns to AFDC for support of the child, or she decides to renege on her agreement and applies for non-AFDC paternity establishment services. Does she, or does the child, still have a cause of action? Until recently, the validity of such an agreement was judged solely on simple contract principles, and the mother generally was barred from further legal action if there was consideration behind the agreement. In our example, the mother benefited by receiving $500 and suffered a detriment by giving up her cause of action. Thus, the older cases would have held the consideration sufficient to classify the agreement as a contract, and the mother would have been stopped from bringing suit, despite the clear folly of her agreement and its adverse impact on her ability to support the child. Modern appellate decisions and Section 6(d) of the APA refuse to grant binding effect to such agreements, regardless of their terms, unless they have been approved by a court. The language of the APA seems to assume that the agreement should be approved at the time of its making, in conjunction with a pending lawsuit. However, some courts have construed similar language to allow the judge to determine the fairness and adequacy of the agreement at the point in time when the alleged father enters it as a defense to the paternity action. The court then may allow the defense if the agreement was fair. The rule has developed in a slightly different direction regarding the enforceability of the agreement against the alleged father. Even though an agreement may not bind the mother or child, most courts have found the support provisions of an agreement to be enforceable. assuming some form of consideration can be found in the agreement. Furthermore, courts have shown a willingness to stretch the definition of consideration a bit in order to allow the mother to collect arrearages that have accrued under an agreement providing for installment support payments. Consideration has been held to be sufficient where the mother agrees not to file a civil paternity action, agrees to allow the alleged father to exercise some visitation rights or some control over the way the child is raised, agrees to move away, or agrees to give the child the father's name. Some cases hold that the moral duty of a father to support his offspring will suffice as consideration. It also has been held that the child, as third-party beneficiary of such an agreement, has standing to enforce his or her terms against the alleged father. Thus, the agreement may not bind the mother or child as to current or future support, and yet arrearages that have accrued under the agreement may be collectible by way of an action for breach of contract. Of course, many of these agreements will be oral and therefore unenforceable where they call for acts or forbearance that cannot be performed within 1 year. The Statute of Frauds almost always will apply. Furthermore, the language contained in the UP is so broad as to appear to void any such agreement entered into without court approval, even as to the support obligation of the alleged father. The agreement would still constitute an admission against interest, however. Assume that the agreement was fair and adequate when entered, that both parties have performed according to their respective promises, but that a modification appears to be necessary or equitable. Does a court have the authority to enter such a modification? The traditional answer was no, but, again, the law is changing. Many of the modern statutes grant an approved settlement, the status of a judgment, indicating that the support provisions are modifiable to the same extent as any other support order. Other statutes specifically provide that such an agreement is modifiable if the alleged father acknowledged his paternity as part of the agreement. Even without specific statutory authority, it may be that a court's failure to assume jurisdiction for such a purpose would violate the illegitimate child's right to equal protection vis legitimate children. Most states refuse to allow the parents of legitimate children to enter into agreements for future support that purport to bind the courts. See Chapter 9, Supra. As a last resort, it might be possible to couch the action in terms of a request for rescission of an unconscionable contract, given the alleged father's usual advantage in bargaining position at the time such an agreement is entered into. The most frequent contact a court will have with paternity settlements will be those that are made by the 4D agency and passed on to the court for disposition. As pointed out above, the modern statutes generally require that such settlements be court approved, and the Social Security Act probably requires a judgment of some sort. Pleading the action form of the action in most jurisdictions. The modern Paternity Act provides for a civil action, with the exception of the rights afforded indigent paternity defendants to appointed counsel and state-financed blood tests. The action proceeds like any other civil action. The proceeding is initiated with a petition or civil complaint instead of an indictment or criminal information. The purpose of the action is to determine the legal status of the parent-child relationship and not to seek societal retribution against the alleged father. In many jurisdictions, the language of the current statute carries criminal connotations, but the courts endeavor to ascertain the true intention of the legislature, and give it effect, rather than carry out literally the terms employed. 10 Amjurad Bastards Sec. 75, 1963, com. Ex-Rel. Miller v. Dilworth, 204 Pascals. Supra. 420. 205A2D 111, 1964, service of process generally is accomplished upon a civil summons pursuant to state civil service of process statutes and rules, although some of the older statutes still provide for use of a warrant upon which the defendant is arrested, even though the resulting action may be conducted as a civil action. Burden of proof. The burden of proof required by the statute generally follows the form of the proceeding. Modern statutes, including the UPA, clearly assume or specifically provide that the action is civil and adopt the normal civil burden of proof, preponderance of the evidence. Roods v. Roods, 645 P2D 640, Utah 1982. Isaacson v. Obendorf, 581 P2D 350, Idaho 1978. Doe v. Roe 647 P2D 305, Hawaii App. 1982, in Missouri, a state with no specific statutory procedure for determining paternity, it likewise has been held that the applicable burden of proof is preponderance of the evidence. LDV. JD, 481 SW2D 17, Mo.App. 1972, several states have opted for a middle ground, either by statute or court decision, and have adopted the clear and convincing evidence standard. This standard requires evidence that exceeds a mere preponderance but does not require proof beyond a reasonable doubt. At least 2 states, both of which have very criminal-looking statutes, apply the reasonable doubt burden of proof rule. 317 If any trend is discernible, it is toward the adoption of the civil burden, as a result of the gradual enactment of the UPA by the states. Parties under the UPA, Section 9. The child, the natural mother, all presumptive fathers as established by Section 4 of the Act, and all alleged fathers who are within the jurisdiction are necessary parties. This section has been held to be jurisdictional. Matter of Burley, 658 P2D 8, Wash. App. 1983, Perez v. Department of Health. 71 calories. App. 3D 923, 138 calories. RPTR. 32, 1977. In addition, all alleged fathers outside the jurisdiction of the court must be given notice of the proceeding and an opportunity to appear. The UPA grants all these parties standing to bring the action as well. In addition, any interested party may bring an action where a presumption rises because the alleged father has held the child out to the community as his, or has filed a written acknowledgement of paternity with the proper state or local agency. Where no presumption rises under the Act, the state agency that is named in the statute also may bring the action. The Uniform Act on Paternity, UAP, Section 2, contains similar standing provisions, allowing the suit to be commenced by the child, the natural mother, or the public authority chargeable by law with supporting the child. If paternity has been acknowledged, or otherwise determined by law, the list is expanded to include any third party who has provided support to the child. Courts in at least 2 states that have yet to adopt one of the Uniform Acts have dealt with the issue. In S. v. S. 595 SW2D 357, Mo.App. 1980. The Missouri Court of Appeals, Western District, held that the child is a necessary party to any action in which paternity becomes a contested issue, and that a guardian ad litem must be appointed to represent the child's interests. The court stressed the need to avoid conflicts of interest between parents and child, to protect the integrity of the fact-finding process, which too easily can be subverted by collusive suits, and to promote judicial efficiency. Allowing a suit to reach a judgment that is not binding on the child because the child is not made a party promotes duplicitous lawsuits, and is therefore an inefficient use of the judiciary, as well as being potentially unfair to the alleged father, according to the opinion. Conversely, an appellate court in the state of New York has held that the child is not a necessary party to a paternity action brought by the 4D agency. Commissioner of Social Services v. Bailey, 79 App.Diff.2D 572, 424 NIS 2D 24, 1st Department 1980. Some of the older statutes, which tend to be criminal or quasi-criminal in nature, limit the bringing of the action to the local prosecuting attorney, who brings the action on behalf of the county or the state. Under such a statute, neither the child nor the mother are technically parties to the action. The mother acts more in the nature of a complaining witness, and the child is an incidental beneficiary of the action. For an example of this type of statute and its effect on the standing of the parties, see State Ex Rel. Barton v. Villey, 651 P2D 683, Oklahoma. 1982. The Oklahoma statute was held to prohibit an action brought on behalf of the mother by a private attorney, although it was construed to allow the addition of the mother as a party to allow for her representation by counsel other than the prosecutor, but only after the prosecutor files the action. Few appellate decisions discuss the party issue in the 4D context, but the cases that do exist are very interesting. Two cases stand for the proposition that 4D paternity cases are brought by the state on behalf of the child, and that the proper nominal plaintiff is the child, not the custodial parent. State Ex Rel. Warren v. Mahan, 329 NW 2D 673, Lower 1983, State Ex Rel. Adult and Family Services Division v. Bradley, 666 P2D 249, or 1983. The latter case further held that since the state is asserting the rights of the child, the state can raise any issue which could be raised by the child. Perhaps the most interesting line of cases is from the state of Washington, where the courts have discussed the proper procedure for adding the child to the action as party plaintiff. Section 9 of the APA requires that the child be a party to the action and that a guardian ad litem be appointed to represent the child's interests. The Act presumes that the interests of the parents and the child are too divergent to allow either of them to represent the child. Requiring the action to be brought in the name of the child and the appointment of a guardian ad litem creates a procedural problem. Normally, the natural mother acts as next friends to the child and files the action on the child's behalf. After the action is commenced, and it is clear that the alleged father intends to contest paternity, the court appoints the guardian. Two Washington cases agree that the Act prohibits the natural mother from representing the child even for the limited purpose of filing the action, and further appear to hold that the child must be served, either personally or through the guardian ad litem, with the initial process before the court obtains jurisdiction. State v. Doughty, 92 Wash. 930, 603 P2D 373, 1979. Hayward v. Hanson, 97 Wash. 614, 647 P2D 1030, 1982. To handle this problem, someone other than the natural mother could act as next friend for the limited purpose of filing the petition. Then the court could enter an immediate ex parte order appointing the guardian, who can accept service of process on behalf of the child. Washington chose to pursue an even more fundamental solution by amending the statute to allow the 4D agency to bring the action without naming the child as a party. Guardians ad litem. As noted above, there is a discernible trend toward requiring the addition of the child as party plaintiff and the appointment of a guardian ad litem to represent the child's interests. Unfortunately, there is some confusion about the proper function of the guardian ad litem. The APA does little to lessen the confusion. It merely states that the child may be represented by its general guardian or a guardian ad litem without any guidance concerning the responsibilities which attach to the office. A court generally appoints a guardian ad litem to represent the interests of infant defendants, whereas a next friend normally functions in a corresponding capac for infant plaintiffs. However, a next friend's function generally is limited to acting as nominal plaintiff to avoid the legal incapacity suffered by the child as a result of his minority. A guardian ad litem has considerably more extensive duties, and is generally representing the child in a legal capacity and as an officer of the court. 32 As a result, the list from which most courts select guardians ad litem often is composed exclusively of attorneys, who convert the paternity trial into a three-party lawsuit. If the guardian ad litem takes his or her responsibility seriously, he or she should be actively involved in discovery, pre-trial negotiations, and the trial itself, including appeals. It is difficult to reconcile this concept of the function of the guardian ad litem with the practice in some states of appointing the 4D agency as next friend or guardian ad litem. Clearly, the interests of the 4D agency can diverge from those of the child to the same extent as the natural mother's. In states that require a guardian ad litem, the appointment generally is accomplished by filing a motion with the court. The appointment is by ex parte order of the court. Pre-trial motion practice. Pre-trial hearing. The APA and many of the modern civil paternity statutes provide for a pre-trial hearing. The purpose of the pre-trial hearing is to inform the defendant of the nature and effect of the paternity proceeding and his due process rights, encourage negotiation and settlement, and provide some structure to the discovery process. The comment to Section 10 of the Act states that the purpose is to minimize inconvenience and embarrassment to the parties in the vast majority of cases that will be resolved by consent as a result of blood test evidence. The public is barred from attending the pre-trial hearing. At the pre-trial hearing, the parties may present and cross-examine witnesses, make motions for blood tests, and present other evidence relevant to the paternity issue. On the basis of the information presented at the hearing, the judge or referee determines whether a judicial determination is in the best interests of the child, and makes a recommendation to the parties regarding settlement of the case. The Uniform Act specifically refers to the guardian ad litem's role in the settlement negotiations. In Wisconsin, the availability for cross-examination of an adverse party provided by the pre-trial hearing has been held to preclude the use of interrogatories in paternity actions. State Ex Rel. Opelt v. Crisp, 81 Wis. 2d 106, 260 NW 2d 25, 1977. The same logic would appear to apply to depositions, at least as to adverse parties and witnesses who are identified and available for cross-examination at the time of the pre-trial hearing. Thus, the pre-trial hearing can simplify the discovery process significantly and speed up the pre-trial phase of the proceeding. Another Wisconsin case holds that the court is without authority to enter a blood test order prior to the preliminary hearing. State Ex Rel. Scott v. Slocum, 109 Wis. 2d 397, 326 NW 2d 118, App. 1982. At least in Wisconsin, the preliminary hearing appears to be developing into the principal discovery mechanism. The blood test decision takes the concept one step further and recognizes that one of the purposes of the pre-trial hearing is to provide the alleged father with an additional degree of protection, by requiring a probable cause determination by the court before the proceeding may continue. Temporary support. Some paternity statutes allow for the entry of a support order pendente lite. The entry of such an order without some sort of probable cause hearing would appear to raise some due process problems. In states where the statute provides for it, the pre-trial hearing is clearly the most appropriate forum for such a determination. In states without statutory authority for the entry of a temporary support order, the court may have to rely on its inherent authority to make such a provision. A good analogy can be drawn between this situation and the remedy of the preliminary mandatory injunction. Assuming that the court sitting in the case has some equity powers, the facts should support the requirements for an injunction, as follows. The plaintiff is likely to prevail on the merits. This would have to be established at the pre-trial hearing or the hearing on the motion for temporary support. The plaintiff is likely to suffer irreparable injury should the order not issue. The theory being that there is no way for the child to exercise his or her right to paternal support after the fact. There exists no adequate remedy at law. The counterargument here is that the reimbursement judgment, which the court is empowered to enter on disposition of the suit, is adequate. From the child's point of view, this is clearly not the case. The child is going to have to do without the added support, and permanently suffer to some degree, or be forced to turn to public assistance. As additional ammunition for the inherent authority argument, it can be noted that the legislature has provided for temporary support orders in dissolution proceedings. Any failure to provide a similar remedy for illegitimate children arguably constitutes a violation of the Equal Protection Clause unless the state can establish that the discrimination is related to a substantial and proper state interest. To be sure, the question of the alleged father's paternity constitutes a logically compelling reason to discriminate in this situation. The state has a valid interest in assuring that men are not forced to support children who may be adjudged to have been fathered by other men. However, an alternative exists that is less restrictive than denying the illegitimate child the remedy. The less restrictive alternative is provided by the pre-trial hearing procedure contained in the UP and by the type of hearing that is afforded a defendant in the preliminary injunction situation. In Minnesota, if blood tests indicate a 92% likelihood of paternity, the court, upon motion, will order temporary support. Minnesota.stat, seconds. 257.62, subbed. 5. A temporary order is extremely helpful in speeding up the proceeding because the alleged father no longer benefits from delay. Furthermore, experience has shown that, even where a court enters a reimbursement judgment for the period during which a paternity case is pending. It is very difficult to collect such amounts from the father. It is also clear that saddling him with a several $1,000 judgment may reduce significantly his ability to provide current support to the child. Adopting the collect-as-you-go approach provided by temporary orders furthers two laudable policy considerations. The child and the state benefit from the alleged father's financial contributions during the pendency of the suit, which is likely to be a shorter time period than would be the case without the temporary order, and the child will benefit after the fact because the father will be able to devote a greater percentage of his income to current support. Motions for physical and mental examinations. Genetic paternity testing is the most powerful form of discovery available for contested paternity cases. The results often lead to a negotiated settlement or dismissal. In most cases, the testing can be arranged for and conducted without the need of a court hearing. When such a stipulation cannot be obtained, it is necessary to move the court for an order directing the parties to submit to testing. Most paternity statutes contain specific authority for the entry of an order requiring the parties to submit to blood tests. Without such specific statutory authority, the usual method of authorization is the civil discovery rule allowing for physical and mental examinations. The model rule here is Federal Rule of Civil Procedure. In addition to blood tests, physical examinations are occasionally necessary to confirm the existence of identifying birthmarks or moles on the alleged father's body to prove intimacy between the parties. Insanity is not a defense to a paternity action, even under a criminal statute, so mental examinations should not be relevant. The federal rule applies only to parties to the action and persons under their custody or legal control. The latter requirement clearly was drafted to include a non-party child in a paternity case. Note that under this rule other men must be joined as third-party defendants before the court is authorized to order them to submit to testing. Such joinder may not be necessary under the more specific provisions contained in modern civil paternity statutes. Orders directing a party to submit to a physical exam are available only upon good cause shown under the federal rule. Given the publicity scientific paternity testing has received in recent years, and the fact that many of the newer statutes require them to be administered in every paternity case, the good cause requirement should not pose a problem. However, it may come up in the birthmark search situation. If the alleged father objects to the inspection of his body, the plaintiff will have to inform the court of the precise target of the inquiry. The court apparently has some discretion to refuse to appoint the expert or laboratory suggested by the movement and appoint in lieu thereof an expert or laboratory of its own choosing. Many judges prefer to use the same expert witness time after time. The party on whom the examination is performed has an absolute right to receive, on request, a copy of the resulting report, but by accepting a copy he waives his privilege to withhold past or future examination reports regarding the same physical condition. Occasionally, an alleged father will challenge the constitutionality of the order to submit to blood testing. These challenges may include the following: the alleged father's right to privacy is being unlawfully abridged, the blood drawing constitutes an unreasonable search and seizure, allowing the test to be performed on an alleged father whose religious beliefs prohibit the drawing of blood violates his First Amendment rights. The testing unlawfully requires the alleged father to incriminate himself in violation of the Fifth Amendment. All of these arguments have been rejected. However, these decisions do not go so far as to establish that blood may be drawn over the objection of an alleged father who refuses to volunteer a vein. A number of decisions in criminal cases uphold the drawing of blood from a non-consenting defendant. Schmerber v. California, 384 U.S. 757, 86 SCT 1826, 16 led 2D 908. 1966. Because constitutional limitations are given more weight in criminal cases than in civil cases, it is probable that a similar holding would result for paternity testing. The authors are aware of no statutes which specifically provide for involuntary blood drawing. However, there are few remedies if an alleged father simply refuses to comply with the blood test order. Some of the modern statutes provide for enforcement by civil contempt, a sanction which no doubt would be effective. In most other states, the situation is bleak. The court may apply normal discovery sanctions, at least in federal rule states. after the disobedient party has refused to comply with an order to compel discovery. Applicable sanctions include an order of the court establishing the matters to which the discovery order applied in accordance with the claim of the party who obtained the order, an order refusing to allow the disobedient party to support or oppose designated claims, or prohibiting him from introducing designated matters in evidence. Clearly, the alleged father would not attempt to introduce his own test results, and it is difficult to conceive of a way the court could tailor a sanction which logically would relate to the disobedience. An order striking pleadings, staying the proceedings until the order is obeyed, dismissing the action, or rendering a default judgment against the disobedient party. The first three are effective against plaintiffs only, and the default option is perhaps too severe, given the fundamental interests of the alleged father and the child in an accurate determination of paternity. See County of Hennepin ex rel. Bartlow v. Brinkman, NW2D-11 Floor 1274, Minnesota. App. 1985, an order treating the failure as contempt of court, except as to orders to submit to a physical or mental examination. Here, the rule itself contains the bad news. Clearly, legislation offers the best solution to the problem of alleged fathers who refuse to submit to testing. In the meantime, judges and attorneys need to be thinking of an appropriate sanction should the issue ever arise. There is a Minnesota decision which holds that an alleged father's refusal to undergo paternity testing may be brought out at trial to create an inference unfavorable to his defense of non-paternity. State on behalf of Orloff v. Hansen, 277 NW2D 205, Minnesota. 1979. Motions in limine in jury trials. Defense counsel often will try to place doubt in jurors' minds by referring to matters that are highly prejudicial, but that are clearly irrelevant or otherwise inadmissible. As one common tactic, defense counsel inquires of every plaintiff's witness, "Do you know John Doe?" without ever identifying John Doe or explaining his relevance to the case. Plaintiff's counsel no doubt could get an objection sustained to halt the tactic, but at the sizable cost of appearing to the jury to be hiding the existence of another man. To ward off such a tactic, an attorney may file a motion in limine, asking the court to enter a pre-trial order prohibiting defense counsel from seeking to admit evidence of inadmissible and prejudicial subject matter. In addition to non-specific references to other men, attorneys may opt to include in the motion any other type of inadmissible evidence which might be prejudicial where appropriate to the facts of the case, such as references to other illegitimate children born to the mother, references to contraceptives used, or not used, by the mother before, during, or after the probable period of conception, references to the marital status of the mother's parents, references to the mother's reputation in the community for sexual promiscuity, references to abortions had, or allegedly had, by the mother, references to sexual encounters between the mother and other men outside the probable period of conception. A motion in limine achieves 6 interrelated objectives as follows. Isolating prejudicial evidence from the jury, Bridges v. Richardson, 163 Tex. 292, 354 SW2D 366, 1962, Sacramento and San Joaquin Drainage Dist. v. Reed. 215 calories. Tap.2D 60, 29 calories. RPTR. 847, 1968. Discovering the opponent's case, or theory, as to the admissibility of the contested evidence. Forcing election by the opponent. Often, in response to the motion, opposing counsel will argue that the evidence in question is admissible, but only for a limited purpose, one that is often neither prejudicial to the plaintiff nor useful to the defendant. Preserving record on appeal. Montgomery v. Visant, 297 SW2D 350, text.sif.app. 1957, obtaining favorable settlement offers. Simplifying the trial. Non-scientific evidence. Once pre-trial motions and proceedings are complete and the jury is selected, the paternity case is ready for trial. In both jury and bench trials, both attorneys normally make an opening statement, to present a persuasive summary of their client's allegations and to tie them, generally or specifically, to the forthcoming evidence. Some jurisdictions limit the opening statement to a general outline or summary of the allegations. Others permit, or even require, a detailed presentation of the evidence that the attorney expects to prove by each witness. Trial attorneys disagree over which tactic is more desirable. Next, each side presents its evidence. This section discusses the types of non-scientific evidence that state courts and legislatures have determined to be legally relevant in paternity proceedings. The following section discusses the admissibility of scientific paternity testing results and the extent of the foundation necessary for their introduction at trial. Uniform Acts, both the UP and the UAP, contain specific sections on the types of evidence which are admissible in a paternity action. Section 12 of the UP provides that all evidence relevant to the paternity of the child is admissible, and further sets out 4 categories of evidence which are specifically admissible, as follows. Evidence of sexual intercourse between the mother and alleged father at any possible time of conception. An expert's opinion concerning the statistical probability of the alleged father's paternity based upon the duration of the mother's pregnancy. Blood test results, weighted in accordance with evidence, if available, of the statistical probability of the alleged father's paternity. Medical or anthropological evidence relating to the alleged father's paternity of the child based on tests performed by experts. Section 14 contains 2 limitations concerning the admissibility of evidence regarding the mother's sexual activity. Testimony relating to sexual access to the mother by an unidentified man at any time, or by an identified man at a time other than the probable time of conception of the child, is inadmissible unless offered by the mother. Evidence offered by the alleged father relating to sexual intercourse between the mother and another man during the probable period of conception is admissible only if the other man has undergone blood tests and has not been excluded as a possible father of the child. Only about a dozen states have enacted the UPA. However, the fact that the UPA contains these evidentiary limitations makes a very good argument for their application in states that have yet to adopt the Act, unless there is existing case law to the contrary or conflicting language in the state's paternity statute. Mother's testimony standing alone. While there is some case law to the contrary, the overwhelming majority opinion is that the mother's uncorroborated testimony, if sufficiently credible, is sufficient to support a finding of paternity. P. V. V. L.W. 93 NM 577, 603 P2D 316, N.M.App. 1980, Dorsey v. English, 283 MD. 522, 398 2D 1133, 1978, 10 AM.J.2D Bastards. Seconds 110. The issue of corroboration has found its way into the case law because many 19th and early 20th century criminal bastardy statutes required corroboration of the mother's claim as a condition precedent to filing the complaint. Clearly, the lone testimony of the mother should defeat a defendant's motion for summary judgment. Child's birth certificate. As a rule, the birth certificate is admitted by stipulation for the limited purpose of establishing the birth of the child and, perhaps, the birth weight. One Illinois decision holds that a certificate that indicates no father is probative that the child was born out of wedlock. People ex rel. Ashford v. Ziman, 61-3 December 741, 110-3 App.3D 34, 441 NE2D 1255, 1982. There is often a state statute which makes the certificate presumptive evidence of the birth of the child. See, for example, cal.evid.code, seconds 1281 and 1530. Even without the statute, the certificate would seem to qualify as a business, official, or hospital record, so that no hearsay objection would be sustained as to the admissibility of the certificate to prove the medical circumstances surrounding the birth. Once the proper foundation is laid, the appearance on the certificate of the alleged father's name in the child's father space would seem to add another layer of hearsay which would not qualify for admission as a business or hospital record, unless his name was entered as a result of some sort of acknowledgement made by him, and entered by an employee of the hospital in the ordinary course of preparing the certificate. If the father's name or other identifying characteristics appear on the certificate as a result of the attestations of the mother, the statement is no doubt too self-serving to be of any probative value, except perhaps as a prior consistent statement. The alleged father's name rarely will appear on the certificate, either because the mother was married to another man on the date the child was born, or because the alleged father has refused to comply with an acknowledgement procedure mandated by statute. State law often requires the name of the mother's husband to be entered on the certificate, regardless of the true biological facts, and prohibits the listing of a father for illegitimate children prior to the entry of a judgment of paternity or statutory acknowledgement. Counsel for alleged fathers often will try to confuse the jury by making it appear as though the mother was unsure of the identity of the father at the time the certificate was prepared. Plaintiff's counsel may anticipate this problem and request a direction from the court through a motion in limine. Admissions of the alleged father. This is clearly one of the most powerful forms of evidence. Any acknowledgement by the alleged father of even the possibility of his paternity severely damages any of his potential defenses. Declarations of the alleged father are admissible over a hearsay objection as admissions 43 and can consist of oral or written statements or conduct that has a communicative effect. Evidence of acknowledgement may include a statement by the alleged father, made after the mother becomes pregnant, that the child is his, including participation in the filling out of the birth certificate. The alleged father's taking the mother to prenatal doctor's appointments. The alleged father's taking the mother to the hospital and arranging for her admission. The alleged father's visiting the mother and child at the hospital. The alleged father's arranging for the discharge of the mother and child from the hospital and signing the necessary release forms. The alleged father's bringing the mother or child into his home after discharge from the hospital. The alleged father's displaying the child to others and holding the child out to the community as his. The alleged father's providing for or making payments for the care, maintenance, and support of the child. The alleged father's suggestion that the mother get an abortion upon learning that she is pregnant. The alleged father's silence when repeatedly confronted with the allegation that he is the father. The alleged father's filing of a tax return listing the child as a dependent. The alleged father's having cohabited with the mother during the gestation period. The alleged father's complicity in the child's use of his surname. The alleged father's presence at the child's baptism and failure to object to his name appearing on the baptismal certificates. The alleged father's visitation of the child after discharge from the hospital. The alleged father's buying gifts for the child. Prior declarations of the mother. Generally, prior statements of the mother are held to be inadmissible as self-serving and not probative. Under Federal Rule of Evidence 801, c. 1, b, prior consistent statements are admissible only after a charge of recent fabrication or improper influence has been made to impeach a witness's testimony. Some jurisdictions include declarations made by the mother during labor. Some decisions have held that, because the defendant's denial of paternity challenges the plaintiff's veracity, prior consistent declarations always are admissible. People ex rel. Ashford v. Ziman, Supra. Testimony on sexual intercourse between mother and alleged father. Clearly, testimony of sexual intercourse between the parties during the probable period of conception is crucial to the petitioner's case. Witnesses to the act are rare, so the mother generally will provide the testimony on direct examination during petitioner's portion of the trial. Circumstantial evidence is often available from friends and roommates who were aware that the two parties were sleeping together in the same room, or who witnessed the parties together in equivocal circumstances such as would lead the guarded discretion of a reasonable and just man to conclude that sexual intercourse had occurred between the parties. A related issue is the admissibility of evidence regarding sexual activity between the parties which occurred outside the probable period of conception. Such evidence can help establish the extent of the intimacy that existed between the parties and therefore the credibility to be assigned to both parties' testimony. The majority rule is that such evidence is admissible if the sexual activity is not too remote in time to support an inference that the intimacy continued into the conceptive period. Defining the probable period of conception. It is necessary to define the probable period of conception for two reasons. First, the mother's testimony regarding her sexual activity with the alleged father must be given some biological relevance to the birth of the child. Second, a period of time must be established to limit the alleged father's evidence regarding the mother's sexual activity with other men. As with most potentially disputable facts, this issue is often resolved with a stipulation prior to trial. The extent to which this is possible naturally will depend on the nature of the alleged father's defense, especially regarding the existence of other men. One common defense tactic is to make the mother appear confused as to the date of her last menstrual period. If the alleged father's attorney can shake her testimony on this issue, then her entire testimony becomes suspect, and evidence of her alleged activity with other men becomes easy to introduce. In most states, the court may take judicial notice of the normal gestation period of 280 days or 10 lunar months. 55. Actually, this period measures the normal passage of time from the beginning of the mother's last menstrual period to the birth of the child. The average gestation period is 267 days. The legal literature often misquotes the medical literature. Thus, the date of conception is computed by counting backwards from the date the child was born. The date of birth can be established by introduction of the birth certificate or with live testimony from the mother. It also has been held that the state of pregnancy is such a common condition that a woman may give her own opinion as to when she became pregnant. Goody v. Pinto, 37 Connecticut. Supra. 786, 436 A2D 1099. 1981, a few states have enacted a statute that determines the probable date of conception, again counting back from the date of birth. See Wis. Stat.An. Seconds. 891.395. The Wisconsin statute creates a presumption that conception occurred within a span of time extending from 240 to 300 days before date of birth. To cause the presumption to arise, it must be proved that the child was a full-term baby, which in turn is established by showing that the birth weight exceeded 5½ pounds. Occasionally, the mother will claim to have had sexual intercourse with the alleged father and no one else but during a period that is slightly outside the presumptive period. When this occurs, an expert witness may be called to testify that gestation periods commonly vary from the norm and that the child in question was either premature or past due. The party alleging an abnormal gestation period has the burden of proof on that issue. Physical resemblance between child and alleged father. Authorities are split regarding the admissibility of evidence offered to establish that the child and alleged father share similar physical characteristics. There are two popular methods of presenting such evidence. The simplest way is to place the alleged father next to the child, and allow the jury to view their similarities, without any reference to specific features. The specific demonstrative similarities can be emphasized with questions to the parties and during opening and closing argument. See Commonwealth v. Kennedy, 383 Mass. 308, 450 NE2D 167, 1983, State v. Green, 284 SE2D 688, N.C.App. 1981, in states that allow exhibition of the child to the jury, a condition to the general rule sometimes states that the child must be old enough to have developed settled features. The judge has considerable discretion regarding the determination of both this issue and the propriety of allowing the child to be exhibited for this purpose. 10 Amjur 2D Bastards, Seconds. 120, 95 ALR 309, 1935. In some states, a live witness must testify that, in his or her opinion, the child resembles the alleged father or other members of his family. 10 Amjur 2D Bastards, Seconds 41. Other states will not allow lay opinion testimony on the subject, but will allow expert testimony, once a proper foundation is laid to establish the witness as an expert and to establish that the testimony is based on accepted and reliable scientific principles. State Ex Rel. Salem v. Davis, 54 Wis.2D 446, 193 NW2D 43, 1972, Amida v. Kara, 51 Hor. 594, 465 P2D 564, 1970, without the foundation. such testimony is inherently unsatisfactory. With the exception of cases where the child and alleged father share a physical characteristic for which a population distribution has been developed, it would appear impossible to lay a proper foundation. The expert could testify that the trait is transmitted genetically, but the expert's inability to report on how frequently the trait appears in the population as a whole would dilute the probative value of any expert opinion. The practice adopted by many of the newer statutes, which require the addition of the child as a party to the action, would seem to end all prohibitions against the child being in the courtroom during the trial, and the availability of extended factor genetic paternity testing would seem to erase the need for using resemblance as evidence, except in very unusual cases, for example, children who are biracial, have genetic abnormalities, or exhibit recessive traits. Evidence of impotency or sterility. The recent popularity of vasectomies and the fact that credible evidence of impotency or sterility no doubt would be case dispositive make it probable that this issue someday will be raised as a defense in every court that handles a high volume of paternity cases. Impotency is a difficult defense to prove. According to estimates, 90% of male impotency results from psychological factors. Since the psychological impact of the problem can differ from one sexual partner to the next, testimony relating to the potency of the alleged father by persons other than the parties themselves may be irrelevant and therefore inadmissible. Medical testimony regarding impotency caused by organic defects would be admissible, assuming the expert could testify that the defect was present at all times during the probable period of conception. The situation with the sterility defense is similar. Very few men are absolutely sterile. In most men who are referred to as sterile, the defect relates to the number or quality of sperm, making it unlikely that conception will occur with most sexual partners. However, the extent of the defect often varies over time and affects fertility to a different extent from one partner to the next. Since it is impossible to recreate the conditions in vivo on the day the child was conceived, it can be argued that the results of fertility tests conducted for use at trial are inadmissible because the test conditions were not identical or similar to those which produced the conception. This argument has prevailed in several reported decisions. See, for instance, Houston v. Houston, 199 miscellaneous 469, 99 NIS 2D 199, 1950. Mother's sexual activity. Alleged fathers in paternity cases often try to argue that the mother's promiscuity casts doubt on her allegation. Generally, such evidence is inadmissible unless the sexual activity occurred within the probable period of conception. Crane v. Crane, 662 P2D 538, Idaho 1983, South Carolina Department of Social Services v. Thomas, 274 SC 228, 262 SE 2D 415, 1980, Ramsey County v. SMF, 298 NW 2D 40, Minnesota. 1980. State Ex Rel. Gleason v. Gregg, 633 P2D 1322, or.app. 1981, Uniform Parentage Act, Seconds. 14, Sass. The defense of multiple access, exceptio plurium concubentium, in paternity suits, a comparative analysis, 51 Delane L. Reverend 468. 1977. In at least one state, such allegations must be corroborated in order to be admissible. Moon v. Crawson, 441 NIS 2D 227, nyfam.ct. 1981. Older cases stand for the proposition that such evidence may be admissible for the limited purpose of impeaching the testimony of the mother. 10 Amjurad Bastards, Seconds. 116. This rule may still apply where the mother makes a claim of prior chastity on direct examination. Contraceptive fraud. One issue that has received recent attention in the press and in appellate decisions is contraceptive fraud. In asserting this defense, alleged fathers will admit having had a sexual relationship with the mother, but will deny legal responsibility for the conception, pregnancy, and birth of the child by alleging that the mother fraudulently claimed that she was using contraceptive devices and thus could not become pregnant as a result of the sexual union. The defense has been effective in at least one trial court. In re Pamela P. 7 Flaw 2784, on yfam.ct. 1981, however, appellate courts, including the courts in New York, uniformly have held that such conduct by the mother, if proven, does not constitute a defense to a paternity action. Stephen K. v. Roney L. 164 California, RPTR. 618, 1980, Hughes v. Hutt, 455 A2D 623, 9 Flaw 2278, par. 1983, Fask v. Bonanno, NW2D-11 Flaw 1100, Michigan.ct.app. 1984, Pamela P. v. Frank S. 449 NE2D 713, 9 Flaw 2462, Nikes.app.1983. These decisions recognize that an individual has a constitutional right to decide in private whether or not to conceive a child. This right guarantees the individual freedom from intrusion by the state, at least where the state is attempting to limit the individual's freedom of choice. However, this constitutional right has not been held to prevent the state from imposing a parental obligation upon someone who participated in a conception without the intent to conceive. To do so would be tantamount to allowing the parents to determine, by agreement, the extent of the parental support obligation. Courts and legislatures have been unwilling to allow parents such control in other facts situations, and courts in the above-cited decisions have refused to create an exception to the rule for the man who has been duped fraudulently, or negligently, into believing that conception was impossible. Scientific paternity test results in the Child Support Enforcement Program. Scientific paternity testing has proved a powerful inducement to settlement. Nevertheless, an occasional case with highly positive test results will go to trial. Judges may find it helpful to prepare for this by developing a functional knowledge of the testing procedures, and a theoretical understanding of the genetic and statistical principles that underlie the tests and the way in which the results are presented by the laboratory. These issues are discussed in Chapter 6. This section treats the issue of admissibility. First, the reported case law regarding admissibility in general is identified and analyzed. Next appears a discussion of the proper method of laying a foundation for introduction in evidence of the test results themselves. Admissibility. The courts in the United States have been slow to accept blood test evidence. The first reported decision in which blood analysis played a key role in a paternity dispute was Commonwealth v. Zamorelli in 1931. A new trial was granted in that case on the basis of test results showing that the defendant could not have fathered the child in question. 15 years later, however, the California Supreme Court still deemed similar evidence inconclusive. In a case that attracted national attention, a popular comedian was ordered to support an out-of-wedlock child, even though blood tests showed that he could not be the child's biological father. Now, finally, blood tests excluding the possibility of paternity are accorded decisive evidentiary weight by all courts. The state of Iowa recognized early the principle of exclusion of the possibility of paternity based upon incompatibility of blood groups. The uncontradicted testimony of the expert negativing paternity should be final. If it is doubted, other experts could take new tests until the facts of the blood content could be shown with accuracy. Then, where this was established, but one result would be possible scientifically, and for a court to hold the contrary seems absurdity. 25 Iowa LR 823, 825, May, 1941. Iowa also has been cited as one of the first states, perhaps the first state, to endorse, albeit tacitly, the principle that genetic similarity of the child's and the alleged father's blood may be used as affirmative evidence of paternity. 627 in the case of Livermore v. Livermore, 233 Iowa 1155, 11 NW2D 389, 1943, both sides offered test evidence. On appeal, The defendant assigned as error the admission of expert testimony relating to the fact that he could not be excluded. The test results did not indicate a probability of paternity. The court found no merit in the contention that this evidence was improper, and judgment was affirmed. Livermore, Supra, at 393. The tests employed in Livermore, Supra, only could have shown that the defendant was a member of a group of men with similar blood types, which included nearly half of the male population. The case does not specify which tests were employed, but the only systems commonly typed at the time were ABO, M&S, and RHHR. If all of these tests had been performed, only about 53% of the random male population could have been excluded as possible fathers. In fact, until very recently, the courts staunchly limited their acceptance of blood grouping evidence to the same three systems, ABO, M&S, and RHHR, that were available 40 years ago when Livermore was decided. Together these tests give wrongly accused father a slightly better than 50-50 chance of proving his non-paternity. Many states recently have considered the question of the admissibility of extended factor paternity testing as positive proof of paternity. A New Jersey appellate court has stated flatly that HLA is accepted in the scientific community and that HLA test results are admissible. Malvasi v. Malvasi, 167 N.J. Supra, 513, 401 A2D 279, ch.diff. 1979. In California, non-exclusionary HLA test results are admissible as one factor to be weighed among all the other evidence. Kramer v. Morrison, 153 calories. RPTR. 865, 88 calories. App. 3D 873, 1979. With respect to the exclusionary findings, the result of exclusion of paternity by the HLA blood test is conclusive on that issue. Michael B. v. Superior Court of Stanislaus County, 86 calories. App. 3RD 1006, 150 calories. RPTR. 586, 1978. Alaska has instituted a law providing a presumption of paternity if blood tests show a 95% or greater likelihood of paternity. As noted above, the UPA specifically provides that scientific paternity test results are admissible for the purpose of proving the alleged father's paternity of the child, in addition to being case determinative where an exclusion is shown. The UPA is in effect in Colorado, Hawaii, Minnesota, Montana, North Dakota, Washington, and Wyoming. The Uniform Act on Blood Tests, Section 4, contains similar language. This provision, or one substantially similar, is in effect in 9 states: Kentucky, Louisiana, Maine, Mississippi, New Hampshire, Oregon, Pennsylvania, Rhode Island, and Utah. 66 California and Illinois recently amended their versions of one of these uniform acts to allow for the admissibility of test results as evidence of paternity. Several other states, including Arizona, Georgia, Indiana, Iowa, Kansas, Maryland, Nevada, New York, North Carolina, Ohio, Texas, Virginia, and Wisconsin, have enacted independent blood testing statutes that support inclusionary admissibility. Some jurisdictions have allowed the results of HLA tests to be admitted into evidence as positive proof, despite the existence of statutes which specifically limited blood test evidence to the exclusionary variety. See, for example, County of Fresno v. Superior Court, 154 calories. RPTR. 660, California App. 1979, Kramer v. Morrison, Supra, Camden County Board of Social Services v. Kellner, 6th floor 2412, n.j.gif.dom.rul.ct. 1980, Miller v. Smith, 6th floor 2660, il.sir.ct. First Dist. 1980, and Kachemba v. Payne, 466 A2D 1240, d.c.ct.app. 1982, see also Phillips v. Jackson, 615 P2D 1228, 1233. Utah 1980. These decisions simply have refused to apply prohibitive statutory language to extended factor genetic testing. The holdings narrowly define the concept of blood test to include only their Landstiner red blood cell test, generally the only testing procedure in use when the relevant statute was enacted. By using the restrictive definition, HLA and serum and protein tests become something other than blood tests and thus are not prohibited by the statute. In the absence of specific statutory language, the admissibility of paternity test results is determined by applying the usual test for scientific evidence. The case that established the applicable standard is Fry v. United States, 293 F. 1013, D.C.Sir. 23. Under Fry, scientific evidence is admissible only if the scientific principle involved is considered generally reliable and accurate by the scientific community concerned. HLA paternity test results have been deemed reliable and accurate for purposes of the Fry test, and thus admissible, by every appellate court that has taken up the issue since 1979. See Carlian v. Weeks, 387 So 2D 465, fla.dis.ct.app. 1980, Tice v. Richardson, 7 Can. App.2D 509, 644 P2D 490, 1982, Commonwealth v. Blazo, 10 Mass.app. 324, 406 NE2D 1323, 1980, Ims v. Clark, 654 SW2D 281, Mo.app. 1983, at least one appellate court has reached a similar conclusion regarding a testing battery which combined the traditional red blood cell antigen tests with an analysis of red blood cell enzymes and serum proteins. State Ex-Rel. DKBV. WGI, 654 SW2D 218, Mo.app. 1983, laying a foundation. Unfortunately, a petition as showing that paternity test results are accurate and reliable is not the end of the admissibility battle. As with all extrinsic evidence, the attorney must lay a proper foundation to satisfy the court that the probative value of the evidence outweighs any prejudice to the parties which might result from allowing it to be introduced. Because alleged fathers and their attorneys typically view paternity test results as very powerful evidence, they often will argue that the potential for prejudice is very high and that the court should adhere to strict rules of evidence regarding admissibility. The essential elements of the foundation are authentication of the results, qualification of the expert, and avoidance of hearsay objections that arise when all parties who took part in the testing procedure are not available to testify. More specifically, as applied to paternity testing, the crucial issues are: was the blood tested the blood of the child, the mother, and the alleged father? Did the blood remain in proper condition until the time of the test so that the results of the tests can be trusted? Did the person administering the test use proper procedures and approved reagents? Did the person administering the test have the scientific knowledge to interpret the tests correctly? If the courts were to require a full and complete answer to all four questions as a condition precedent to the offering of the test results, the prospect of litigating paternity cases in the volume demanded by the 4D program would be frightful indeed. Nothing less than the live testimony of every individual who formed a link in the chain of custody of the blood samples, including every individual who performed a role in the test itself, would be necessary. If such a rule were adopted and enforced, paternity litigation would be prohibitively expensive. Luckily, legislatures and courts have recognized the utility of medical and other scientific evidence and have been lenient in enforcing the technical rules of evidence. However, there must be some assurances that the laboratory that drew and tested the blood samples in any given case followed sound and regular procedures. To make this process more reliable and easier to effect, the American Association of Blood Banks, AB, has instituted the Laboratory Accreditation Program of the American Association of Blood Banks. To earn accreditation from the AB, blood testing laboratories must meet certain standards of reliability. The remainder of this section discusses a workable and sufficient foundation requirement in states that have neither instructive case law nor an ameliorative statute. The foundation can be broken down into three components, as follows. The tests used in the case are accurate and reliable in the opinion of the relevant scientific community. The person who signed the bottom line on the report is qualified to render an expert opinion as to the statistical probability of the alleged father's paternity of the child. The test results apply to the parties to the action. In most states, an attorney can achieve all of these ends without the live testimony of the expert. However, live testimony from at least one employee of the laboratory will be necessary. The accuracy and reliability of extended factor blood testing is becoming easier to prove every day. As noted above, a majority of jurisdictions now have statutes that provide for admissibility of such test results. One appellate court has held that the passage of such a statute constitutes a legislative determination that the approved test or tests are accurate and reliable. Haynes v. Shanholtz, 57 MD.App.92, 468 A2D 1365, 1984. Once the legislature speaks and the proponent makes a showing that the proffered evidence meets the legislative criteria, a court's discretion to consider whether the approved test battery constitutes admissible scientific evidence is severely limited. In states with no statute declaring the test results to be admissible, the court may accept the proffered test as accurate and reliable based on a trial brief that cites case law from other jurisdictions, statutory enactments of other jurisdictions, and medico-legal literature. It is also possible, of course, to use the testimony of the expert, either in person or by way of deposition, to establish the accuracy and reliability of the tests employed. To avoid the cost of transporting the expert to the trial, a videotaped or written deposition may be allowed in lieu of live testimony. This last alternative was ruled admissible in a recent North Dakota Supreme Court case. Williams County Social Services B.D. v. Falcon, 367 NW2D, ND 1985. The qualifications of the expert often are established by stipulation. In absence of a stipulation, the proponent first must show that the potential witness has an ability to draw inferences from facts that are beyond the capability of the average layman. The ability generally must be related to some science, profession, or business occupation, and the witness testimony must aid the trier of fact in the search for truth. The court has wide discretion regarding the conferring of expert status on any given witness. The following areas should be covered: name and occupational history, educational background and training, professional licenses/certifications, areas of specialization, research experience, publications in general, publications concerning paternity testing, teaching experience, attendance at seminars and courses concerning paternity testing experience, providing expert testimony, current employment emphasizing scope of work, supervisory authority, and length of time in position. It may be possible to produce this evidence in submissible form through the use of videotaped depositions. Williams County Social Services B.D. v. Falcon, Supra, or depositions upon written questions. As an absolute last resort, it may be possible to establish the qualifications of the expert with testimony from an employee of the laboratory. There is case law to the effect that the qualifications of persons who make entries in medical records will be presumed unless some indication to the contrary is shown. The final foundation requirement is the authentication of the report. This is the area most ripe for challenge. The two most common objections are essentially hearsay problems. It is crucial to conclude that this is the case, because it will be necessary for the proponent to rely on at least one hearsay exception in order to overcome the objections. The objections are: without the live testimony of every individual who handled the blood samples from the time they were drawn until the test was complete, the chain of custody is incomplete and the test results cannot be authenticated, that is, proved to be based on the blood samples provided by the parties to the lawsuit. Any opinion contained in the test result report is hearsay without the live testimony of the expert, and double hearsay to the extent that the expert opinion is based on the results of laboratory procedures carried out by persons other than the expert. Most states that have adopted the UP blood test statute based on Section 10 of the UAP have a distinct advantage. The UAP provides that a verified expert's report submitted to the court, which contains documentation of the chain of custody of the specimens, is admissible unless a challenge has been made prior to trial. Lower does not have the UAP, however, It is a model blood test statute, which has given it much the same advantage. ICAR subsect 675.41. Two lower decisions have construed this lower provision to allow for introduction of the report without accompanying live testimony. State Ex Rel. Bushler v. Vincent, 318 NW2D 208, lower 1982, State Ex Rel. Hodges v. Fitzpatrick, NW2D, lower App. 25 October 1983, the latter case points out that, as an exception to the hearsay rule, the statute will be construed narrowly and that all statutory requirements must be adhered to. In that case, the report was held to be inadmissible because the expert submitted it to the plaintiff's counsel instead of directly to the court as required by the statute. The case also held that a challenge filed 1 day prior to trial was timely. In most states, no such specific statutory shortcut is available. There are often other statutory alternatives that avoid the necessity of an appearance by the expert. Many states have adopted a version of the Uniform Business Records as Evidence Act 2 or 13, the Uniform Rules of Evidence, or have case law establishing a similar rule. If such authority exists, it should be possible for the proponent to qualify the report as a business record and thereby escape the hearsay problem. Several decisions conclude that a hospital or laboratory is a business for purposes of the exception. See State v. Carter, 591 SW2D 219, Mo.App. 1979, McCormick on Evidence, Seconds 313, pp. 730 to 733, to take advantage of the business records exception, it will be necessary to bring in the venipuncturist to testify to the drawing and packaging of the blood samples and their delivery to an agent of the laboratory. Once it is established that the samples were delivered to the laboratory, any competent employee of the laboratory should be able to lay a foundation for the introduction of the test report. The witness will have to be familiar enough with the identity and mode of preparation of the test report to testify that the document was prepared in the ordinary course of business, that the entries on the report were made at or near the time of the transaction recorded, and that all necessary procedures and documentation protocols were followed. It is particularly important that the witness establish the chain of custody from entries made on the report document by employees of the lab, as well as identify the signature of the expert. In states that have not adopted a business records statute, case law should provide similar authority. The second hearsay problem concerns the fact that the expert may not have supervised the lab technicians directly as they carried out the procedures to isolate and identify the genetic characteristics of the individuals tested. Again, a Uniform Act can come to the rescue. The Uniform Composite Reports as Evidence Act provides that an expert may testify to his conclusions even where they are based wholly or partly upon written information furnished by several persons acting for a common purpose. See Houghton v. Houghton, 179 Neb. 275, 137 NW2D 861, 1965, and 3 Wigmore, Evidence, Seconds. 572a, Chadbourne Reverend 1972, in those states which have modeled their court rules on the Federal Rules of Evidence, a similar argument can be made under Federal Rule 803-6. If all else fails, the proponent may argue to the court that the blood test results are admissible under the wildcard exception to the hearsay rule, exemplified by Federal Rule 804b-5. Where the declarant is unavailable to testify, the court has authority to allow hearsay evidence that has circumstantial guarantees of trustworthiness and is offered as evidence on a material fact, is more probative than other evidence the proponent can procure through reasonable efforts. The purposes of the rules of evidence and the interests of justice will be served by admission of the evidence. The blood test report is clearly relevant to a material fact. There are numerous quotations from courts across the country regarding the value of blood test evidence in paternity proceedings. Since test results are prohibitively expensive when the expert must be brought in to testify in person in every case, the interests of justice clearly are not served by strict adherence to the rules. The medical profession frequently makes life and death decisions based on expert opinions produced by similar, or less stringent, procedures. Also, the evidence involved can be reproduced. The cases that establish the importance of a continuous, unbroken chain of custody and live testimony from all persons who took part in the scientific analysis are generally criminal cases involving blood, alcohol levels, which change over time, or blood samples that were obtained at the scene of a crime. In such instances, the defendant's procedural rights are greater than in civil paternity cases. More importantly, the courts have fewer alternatives. The samples could not be re-obtained nor verified. In paternity cases, there are two alternatives that better serve the interests of justice than refusing the admission of the evidence. The alleged father has the opportunity to ask for a second set of tests when he is not satisfied with the results of the first, and he has the opportunity to call the laboratory personnel to testify should he feel the need for extensive cross-examination. It may be possible to avoid the hearsay problem by requesting that the defendant admit that blood tests show certain resemblances based on genetic similarity. If the defendant refuses to admit this fact during discovery, then costs of proof may be taken against him as part of the final judgment.